So, my name is Mariah, and today we're going to be talking about the competency to provide consent to research. So, first thing is just knowing the risks that are involved in research. So, there are multiple forms of research. Research in social and behavioral sciences carry little to no risk of significant harm to subjects, and they have rarely resulted in mal-research litigation. However, research on biomedical matter often do present significant risks for participants. Such research presents serious ethical problems when practiced on persons of questionable competence, which is what we're discussing today. Um, so, decision making. Here's some important terms that we talk about when talking about decision making. Autonomy just is the patient's right to choose whether or not they want to participate. And then paternalism is the clinicians or researchers that are making the decision for the patient. The tension in mental health law between autonomy and paternalism is heightened, specifically if experimental treatments often do not provide direct benefit to the participants. Some of us may be familiar with the Nuremberg Code. So, this was enacted after Nazi Germany carried out some horrible human rights abuse in the name of research. The Nuremberg Code established the legal framework in this area by prohibiting any research using persons who could not provide valid informed consent. And then this kicked off the US enacting their own human rights. So, in the United States, the human subjects research is regulated by rules promulgated by the Department of Health and Human Services and adopted by most other federal agencies as well. These regulations provide administrative review of all human research by local institutional review boards, also known as RIBs. And then here's a little video I attached just going over the importance of IRBs, how they operate, and just their overall involvement with human subjects research. So check that out. So the regulations require the following disclosures. So the first is a statement that the study involves research, an explanation of the purposes of the research, the expected duration of the subject's participation, a description of the research procedures and identification of any experimental procedures. Two, the reasonably foreseeable risks or discomforts to the subject. Three, benefits to the subject or others that the research might yield. Four, appropriate alternative procedures or courses of treatment that might be advantageous to the subject. Five, the extent, if any, of confidentiality of records identifying the subject. Six, if the research involves more than minimal risk, an explanation as to any compensation and whether any medical treatments are available in the event of injury. Seven, a contact for answers to questions regarding the research as well as subject rights. And eight, a statement that participation is voluntary, that refusal to participate will carry no loss of benefits, and that participation may be discontinued at any time without any penalty. And then here are just some additional elements of informed consent that are applicable when appropriate. So the first is if the subject is or may become pregnant, a statement that the treatment or procedure may involve risks to the fetus or embryo or subject, which are currently unforeseeable. Two, circumstances under which the subject's participation may be terminated by the investigator without subject consent. Three, costs that may accrue to the subject as a result of the research. Four, procedures for orderly termination of participation by the subject and potential consequences on withdrawal. Five, a statement that significant new findings developed during the research that may relate to continued participation will be provided to the subject. And lastly, the approximate number of subjects in the study. So, full disclosure requirements can be waived if the proposed research involves nothing more than minimal risk to the subjects. The waiver or alteration will not adversely affect the rights and welfare of the subjects, or the research could not actively be carried out without the waiver or alteration. Uh, Regulations define minimal risk to mean that the probability or magnitude of harm or discomfort anticipated in the research are no greater in and of themselves than those ordinarily encountered in daily life or during the performance of routine physical or psychological examinations or tests. Under the common rule, minimal risk is clarified to include the following. The reference group with respect to how risk is experienced should be the general population and not the group subject to the research. Um, Minimal risk might include high probability but low magnitude risks and high magnitude but low probability risks. And then IRB should avoid overestimating confidentiality risks. Regulations also provide special requirements for research involving participants of uncertain competence. So the first example is prisoners. They are forbidden just because of the potential for coercion, unless the research is one, directly related to study of criminal behavior or incarceration and involves only risks that would be accepted by non-prisoner volunteers, and two, does not involve incentives for participation that would unduly influence directions whether or not to participate. And then another example is children. So research on children generally requires the assent of the children themselves and the permission of their parents as well. Additionally, review is required when the research involves more than a minimal risk to the children or when the potential participants are wards of the state. The IRB may waive requirement for parental consent if parental involvement would harm or at least not protect the potential child participant. So, if the child is being neglected or abused. And then, oddly enough, the Department of Health and Human Services never actually implemented proposed regulations for research involving persons described as the institutionalized mentally infirm. So, research involving psychiatric patients follows just the general regulations on human research and requires the informed consent of the patients themselves or their legal representatives. In general, people with mental disorders are widely recognized as a potentially vulnerable population who may need special protections and particularly careful assessment with respect to their capacity to consent to research participation. So now we're into the assessing competence. So, since the mid 1900s, several research measures have been developed that specifically assess various abilities relevant to competence to consent to research participation. The results broadly parallel those obtained in studies of capacity to consent to treatment. So, first, people with more serious disorders perform more poorly on structured measures of capacity than do either those with less serious disorders or control subjects who did not have a mental illness. People with various mental disorders display impaired capacities relative to comparison subjects with no mental illness. Many individuals with disorders such as schizophrenia and depression display competence-related abilities comparable to those of individuals with no mental illness. In studies of people with major mental disorders, the more severe a person's current symptoms, the worse the person's performance on measures of competence-related abilities. And then, most importantly, poor performance on measures of capacity to consent to research can be remediated by educational interventions that reiterate information and instruct patients on information that was initially poorly understood. So, if you are at first found incompetent, you can go through these educational interventions and be later found competent too. the consent to research. So, in conclusion, to a large extent, an evaluation of competence to consent to research mirrors that of an evaluation of competence to consent to treatment. Yet the clinician should also evaluate the elements of informed consent that are specific to that research. So, the nature of research as opposed to the treatment, freedom to withdraw or set limits, including the fact that withdrawing will have no negative consequences on that participant. And then, when relevant, the lack of benefit to the participant as well. And then here are the references that were used in this presentation today. I do highly encourage you to go and read the primary text, just pages 379 through 382. It will just give you a nice overview and summary of the competency to provide consent to research. Thank you.